Hello everyone, this is my English law channel. I'm George from Ireland. So I'm continuing with implied terms of good faith in contract law. So there are some implied terms of good faith as introduced by various statutes, such as uh, such as one finds in civil law, as in mainland European countries that go by sort of Roman law systems. There can be a situation where the parties are discussing a contract and the contract has not yet come to be extant, and there can be implied term of good faith in that case. Or maybe they imply a term which requires the parties to carry out the contract in good faith. Furthermore, it could be that there's a duty to inform the other party of something from a previous contract. They're contracts which are uberimi fide, of the uttermost good faith. You find that in insurance contracts in particular, where it's not just that you may not lie, that misrepresentations, whether fraudulent or negligent, are forbidden, but the duty is incumbent upon you to say things which are relevant, even if you were not asked about them. So this is contentious. Let me see. So if there's this implication of good faith, then the parties have to be honest, not just to the letter of the law, but sort of in the spirit of the law as well. So not withholding anything which could be material to the contract. So they're parties who owe each other this duty of good faith, such as in Bates against Post Office number 3, 2019. So there were lots of sub-postmasters who got in trouble and they were accused of fraud. They've just all been cleared. There was a glitch in the computer system, and so they were wrongfully convicted. Dozens of postmasters, sub-postmasters and sub-postmistresses accused of having their fingers in the till. Anyway, there were shortfalls in the amount of money the post office had. These people were held personally liable, accused of stealing from the post office, but it wasn't true. So 550 people took legal action, and the High Court ruled that they had contracts in the post office, and these were relational contracts. Therefore, this meant there was an implicit duty of good faith on both parties. So the court, the High Court that is, provided a list of conditions which are pertinent to deciding whether there's a relational contract or not, and therefore if there is an implied term of good faith. So anyway, where there's no term which actually says you don't have to have good faith, this is a factor to consider. The absence of such a term doesn't guarantee that there's no implied duty of good faith. It's just one of several factors. If there's a long-term contract, it's more likely to have an implied duty of good faith. If there's an intention by both parties that the duties be carried out with probity, then again, there's probably an implied term of good faith. If there is a commitment to cooperate between the parties, then there's probably an implied term of good faith. If the agreement is such that it cannot be written out in full because it's too broad, then there's probably an implied term of good faith. Likewise, if the parties trust each other, if they really have confidence in each other's honest dealing, then there's probably an implied term of good faith. If the contract requires many and frequent communications between the two parties with an expectation of fidelity and allegiance between them, there's probably a term of good faith. If both parties have put a lot of time and money into it, there's probably an implicit term of good faith. And likewise, this is an exclusive relationship. If you can only provide this service or these goods to that party, or they can only hire this service or purchase this good from the other party, then again, there's probably an implicit term of good faith. So that's about 10 of them. Now, you wouldn't have to satisfy all 10 for there to be an implicit term of good faith, but the more of them are satisfied, the higher the likelihood there is this implied term of good faith. So the one thing to work out, to think about there, is that there has to be consistency between the terms of the contract which are express and the duties which are implied. Expressed is they're actually said. They're not just taken as going without saying. So this is vital. And that's why in a particular case called SDI Retail Services against Rangers Football Club 2019, it was held that there was no duty of good faith. So coming back to Bates against Post Office, it's a very long case, but in it there was a discussion of these relational contracts, and it said that an relation contract does not bind parties together forever. Look at another case, New Balance against Liverpool Football Club in 2019. Here Liverpool were able to end their contract with New Balance. New Balance used to make their football shirts, and so Liverpool FC signed a contract worth £70 million per annum with Nike. So Liverpool FC's contract with New Balance, which is an American company, allowed them to get the right to find a similar offer from another contractor, such as Nike in this case. So the High Court said that New Balance's bid to offer a contract on similar terms than that proposed by Nike was tendered in good faith, but because of the particular facts of the case, it wasn't quite the same as what Nike was offering. Nike offered other various inducements, such as non-football major sports stars, such as Serena Williams, who are on their books. So Liverpool FC was able to start this new contract with Nike. So there's another case to bear in mind, which is UTB LLC against Liverpool United 2019. So the High Court had to adjudicate a disagreement between two shareholders in Sheffield FC, and they found that there was no implied term in the contract which obliged the shareholders to treat each other with good faith. So this shows how judges are approaching this notion differently, this relational contract, and they're looking at the factors which were stated in Bates. They weren't all use those factors though. So the issue is whether the duty that arises is regarded as a matter of fact or something to do with the legal category it falls into, a relational contract. Anyway, and because of that, it was found that there was no duty of implicit good faith. So anyway, there are implied terms you find in contracts which are there because of what statutes say. We know that there are a number of important statutes in contract law. So let me see. So there are implied duties, and Parliament introduces them. These protect certain categories of party, particularly consumers. So the Consumer Rights Act in 2015 said that there are certain legal provisions which can be applied, although to a different degree according to the circumstances. To apply to contracts if they're between two businesses as a B2B contract, business to business, then it's different. Less protection is afforded to businesses, the idea being that they don't need it so much. But businesses dealing with consumers, well, there's a greater protection for consumers in this case. So anyway, there are two different statutory systems depending on it's a consumer contract or a business-to-business one. So coming to business-to-business contracts, there was a Sale of Goods Act 1979, the Supply of Goods and Services Act 1982. So these are applicable here. So these are the terms which are applicable from the Sale of Goods Act. An implied term that the seller has the right to retail the goods sold. Second of all, there's an implied term that the goods will match the description given. If you're told that it's whatever, it's potatoes you're buying, it can't turn out to be carrots or something. So there are several cases about these. Now, the courts have ruled that teensy differences from what you're told are okay, especially if it's slightly more. If you buy a ton of whatever it is of oats and you get 3 grams more, well, you're not hard done by. If it was 1 milligram less, that would be de minimis. You could still have it. So a ton does not mean about a ton. It was held in Arcos against E.A. Ronarson and Son, 1933. So if it was you asked for a ton, but they actually gave you 3 grams less, that might be beyond the de minimis range, as in you are liable. So things have to fall in with, have to conform to the description that was provided. So it's also about the identity of the item which is actually sold. There's Reardon Smith Line Limited against Hanson Tanger a case often called the Diana Prosperity, 1976. So the Sale of Goods Act, section 14.2, said that there's an implied term that the goods are of decent quality. They don't have to be perfect, they don't have to be excellent, but they must be satisfactory. So the court will look at whether these things satisfactory or not. So they can be first class, they can be second class, but they've got to be usable. So the goods will also, well, the court will also think what price the goods were. If they're below market average, then they will have to be of a lower quality, and that's acceptable so long as they're still satisfactory. Okay, so goods have to be suitable for the purpose for which they are intended. You have to see that they're safe and so on, that they look all right, and that they are reasonably durable, depending on what the service life of the item is supposed to be. Right, the Sale of Goods, section 14.3. So there's in implicit terms that the goods are fit for the reason they are bought. So if you want to buy something like clothes and you wash it in one machine once and it's no longer wearable, well then it wasn't suitable. Okay, so the Sale of Goods Act and the Sale of Goods and Services Act are relevant in business to business contracts. Remember that bit. So anyway, where something is done in the course of a business, but a business seldom deals with another, such as in Stevenson and Rogers, it would still be a business to business contract. So these it has to be satisfactory. However, if the seller draws to the buyer's attention some of the weaknesses or blemishes or whatever of the good, and the buyer buys them nonetheless, then the buyer is not liable. Okay, that's as in a case called Bramhill and Edwards 2004, or if a reasonably careful inspection of the item would have revealed these defects and the buyer doesn't bother to, well then the buyer is liable, caveat emptor, or buyer beware. So there's another provision there in section 13 of the Sale of Goods and Services Act. There's an implied term that anyone providing services shall perform his duties with a reasonable degree of diligence and virtuosity. So, and remember that's only implicit when you're providing it in the course of business. So, looking at business to consumer contracts, the Consumer Rights Act 2015 says there's a duty on all businesses who are dealing with consumers that they've got to be at least as good as the business-to-business contracts, and their duties. They talk about duties, not so much implied terms. So what are the duties of someone operating as a business? That the trader must sell goods which meet the description provided. That's under section 11.1, or section 9 of this is the Consumer Rights Act again. Point 1 is going to be the Consumer Rights Act until I say otherwise. So section 1.9, the vendor has to provide goods which again of a sufficient standard. So they're various, like the factors considered before. There's also a duty to sell goods which are suitable for the thing that they were bought to do. Moreover, under section 49, the business has to carry out his duties with a reasonable level of diligence and virtuosity. Okay, so these duties can hardly be excluded, not as much as you can into business-to-business ones. All right, so probably that's enough about implied duties in contracts. Toodaloo.